Good morning, everyone, and welcome to the first CRIPS AI and Data webinar. My name is Matthew Holman. Thank you very much for giving up 45 minutes of your day to come and hang out with us here. What are we doing? Well, we thought we'd start a new webinar series taking place at lunchtime on the first Monday of every month. Why are we doing it? Well, we're doing it because we want to give you the latest updates on all things that are happening in the world of tech, AI, and privacy. There'll be training sessions in every month that will help count towards your CPD. So we will go away and spend ages reading lots of cases and detailed essays and analysis and anything else we can find. We'll do all that research and reading, and we'll come back and present it to you in bite-sized chunks that will hopefully help you just take away the key things that you need from each of those important developments. There will also be materials. So in every session, hopefully every session, you will get some training materials sent to you. If you've turned up and you've tuned in, we want to say thank you by giving you something that will make the doing of your job a little bit easier. Not just training, not just materials, we'll also give you updates and nuggets of information, the things that we've learned. We'll have guests on. These 3 empty seats will eventually be filled up by more interesting people than me talking about more interesting things. But that is not all. If all we did was turn up every month and deliver training in a webinar, then we would risk being just another boring law firm delivering a boring webinar. But we are not a boring law firm, and this is not a boring webinar. What do I mean? We're all about building communities. We're all about sharing knowledge, and we're all about having fun. That's the point of these webinars. Building communities. By doing this every month, we hope that you'll get to expand your network and meet some new people. And we'll also have some in-person events during the course of the year that you can come to. They'll last a bit longer. We'll be able to look in detail at topics in a way that we can't really do on a time-limited webinar. Through all of this, you'll hopefully get to meet some new AI and privacy geeks and other people that will expand your network and horizons. Having fun, what do I mean? I mean, we take our work extremely seriously. So we want to be the best of the best of the best of what we do, but we don't take ourselves too seriously. Expect banter, giggles, laughter, fun. If we make it all the way through this webinar series and I don't get in trouble, I'll be very, very surprised. Nothing is off limits. There are no stupid questions in an event like this. The only people who aren't invited are the ones they think have got nothing left to learn. And with that unofficial creed, let us begin the AI and Data webinar. I'm going to share my screen with you, which is almost inevitably the cue for something to go fantastically wrong. Let me give it a go. You can't see, by the way, all of you online, the small army of people that I can see in front of me behind camera who are freaking out right now as I start clicking on buttons in the hope that this works. Hopefully you can see a picture of lunch. So, can you see a picture of lunch? You can, excellent. If you weren't hungry before, maybe you're hungry now. Let's look at the first thing we've got on the list of things ahead of us today, which is the things that the ICO is looking at in 2024. I should say before we start that the ICO looks at lots of things all the time, and it says a lot. So the things that we've listed here are the very specific agenda items the ICO has picked for the year 2024, but it's not an exclusive list. Don't assume that because the stuff you do isn't featured here, doesn't mean that you're not going to be looked at. That's not right at all. The first thing is, no drum roll needed, artificial intelligence, the least surprising headline of all. The ICO is going to be looking closely at the use of AI through this year. It's already started one consultation, which concluded last Friday. The CRIPS team here and a bunch of other clients, professionals, and academics worked on that together, and we submitted our response to the ICO on Friday. There'll be consultations running through the year on how data protection law and AI interact with each other. The ICO has said that they think the GDPR still remains the best framework. They don't expect there to be new law, and they expect to work closely with other regulators. What does all of this mean? Well, it means that if you're working in a business that's using AI or planning to use AI, and someone says to you, I'm sure it'll be fine, no one's really interested, are they? The answer is no, you're definitely wrong. The ICO is very interested in this. We need to be interested in it too. What's the second thing that the ICO is looking at this year? Well, the answer to that is children. It marks 2 years since the Children's Code was published. I say children, I actually mean children and vulnerable adults. So anyone who fits into those categories, the ICO is very interested in checking on businesses processing the data of children and vulnerable people. I expect that to be a continued focus throughout 2024. If you're in a sector that involves any processing of the data of children and vulnerable adults, you need to be switched on to the regulatory risk if you weren't already, and I'm sure you probably are. The third thing that the ICO is looking at this year is cookies. It's probably the thing they've spoken about the most. The Information Commissioner has been on a tour and has said all kinds of things like, we're going to change how cookies work for everyone. It's the inflection point between normal people and data protection law, etc., etc., etc. In 2023, they wrote to the biggest top 100 websites in the UK. I feel very privileged to act for a number of those websites, and we worked on all kinds of projects looking at how the cookie compliance works. And what you may not know is that 53 of those 100 that were investigated at the point of first investigation had non-compliant cookie banners, non-compliant cookie processes and policies, but that 38 of them went on to make positive changes, so says the ICO. What they haven't really said is what happened to the 20% who, presumably, based on those numbers, have done nothing at all. ICO very quiet on that one. What they have said is that 2024, they're going to keep going at this. So they're going to find websites working through the hierarchy, so into the top 200 and down and down and down, trying to get cookie compliance to be in a really good place. So if you have a website, I say that without laughing, who doesn't have a website? And if you've got cookies, or if you're doing anything in the online space with cookies and tracking technology, you need to be switched on to the ICO's fact that the ICO are very switched on to you, and they could well be looking at what you're doing. I'm going to end there. We could talk a bit more about what is coming with the ICO, but we've got so much to get through between now and 12:15 that I want to take us on to our second section, which is imaginatively called the Unpacking section. If you could think of a better name, please send it in on the chat or QA function, because it's the best that we could come up with at short notice. But the reason is obvious. We're going to take something really complicated and we're going to explain it very simply. This month's Unpack It is all about the fascinating case of Thaler and the Comptroller of General Patents, and it's asking some really important questions. Let's set the scene. Can a non-human own intellectual property rights? The monkey selfie case of 2015 is a fantastic case, and I presume most of you know what this case is. It's between 2011 and 2015, there was a bunch of litigation about the monkey that managed to take a selfie of itself. The wildlife photographer, David Slater, had set up a scenario where a monkey in its natural habitat picked up a camera, turned it round to its own face, and clicked on the button to take the picture, and what you can see is what happened. The question is, who owns the intellectual property rights in the photo? Is it A, the monkey, because the monkey took the picture, or is it B, the owner of the camera, because the monkey used the camera, or is it C, the wildlife photographer who arranged the whole thing in the first place? It warms my lawyer heart to think of the millions of chargeable hours that were spent litigating the case of whether or not the monkey owned the picture or not. It all ended in 2015 with one of the best sentences that I've ever read in a court case, one that should probably be printed on a t-shirt. It says, "A monkey cannot own copyright under US law." I'm glad that we had that clarified for us. And what does it mean for AI? Well, we'll come to that. The second thing worth thinking about, if you're talking about AI and intellectual property rights is a case that's happening right now called the New York Times versus OpenAI and Microsoft. A group of us here were talking about it just before we came on air. It's a brilliant case and it's still ongoing. We don't really know what the outcome will be. It's all about how OpenAI and Microsoft, the main product that they've released, as you will know, is ChatGPT and its various iterants, along with now Microsoft's Copilot. They were built on large language models. The large language models were built on training data. The training data was built on web scrape data, and that included lots and lots of copy from the New York Times, as well as everything else that you can get on the internet. But it wasn't licensed. It wasn't taken with consent. So the case is about whether or not the intellectual property rights of a third party have been infringed by AI. It's obviously it's not quite the same as Thaler, but there's no way we can talk about AI and intellectual property without talking about that case. We will definitely come back to look at that case once there is a decision on it. Right, let's talk about the case itself. So, Thaler and the Comptroller General Patents. The entire case is perfectly summarized in paragraph 1 of the Supreme Court judgment. One unusual feature of the application is that the inventions are said to have been generated by a machine acting autonomously and powered by artificial intelligence. Another interesting feature is that Dr. Thaler maintains that he is entitled to make and pursue the application on the basis that he is the owner of the machine. Whoops, apologies there. Let's find the right slide. Sorry about that. So what happened? What's the background to the case? Well, in October 18 and in November 18, Dr. Thaler filed 2 patent applications. Neither application designated a human inventor. So if ever you filed a patent application, you will know that it's a fairly boring, bog standard government form. And in it is a box that says, who is the inventor? And into that box, Thaler did not put his own name. Instead, he put the name of the artificial intelligence program that he had developed called Davis. The patent office didn't really know what to do with this. They wrote back to him in November 18 saying, please, can you tell us who the inventor is? And he again wrote back saying, the inventor is Davis. The patent office eventually rejected his application because Davis, in its view, was not a person. Unsurprisingly, he litigated, and it went to the patent hearing office who said, reason 1, you can't have your application is that it does not qualify as an inventor within the meaning of the Patent Act, which, let's face it, is the thing we're all here to argue about. Reason 2, Thaler was not entitled to apply for the patent on behalf of Davis because his own case was that they were autonomously made by something else, i.e. the machine. And the third reason is that Thaler had failed to identify anyone that he believed to be an inventor. So a pretty damning dismissal. You'd think that he might give up at the end of the first hearing, but no. Instead, Thaler goes to, if I can get my slides to work, the High Court. There we go. Hearing 2, High Court, 21st September 2020. Dr. Thaler appeals, and his appeal is dismissed. In other words, he loses. Not content with having lost twice, Thaler goes to the Court of Appeal for Hearing 3, which amazingly is exactly a year to the day later. And there, his appeal is also dismissed, meaning he loses again. However, this is an appeal where he loses on a majority of 2-1, so Lord Justice Burke would permit him to win. If you've drifted off as I was talking, thinking, my goodness, this man has a boring voice, then drift back in now, because this is the most important part. I really want you to catch the gist of these 2 sentences. They're from paragraph 17, and they say, the Court of Appeal held that Davis did not qualify as an inventor within the meaning of the 1977 Act because such an inventor was required to be a person. There is no general rule of law that any intangible property created by a machine is the property of the machine or the owner of the machine. I'll say that again. There is no general rule of law that any intangible property created by a machine is the property of the machine or the owner of the machine. Lord Justice Burst would have permitted the appeal because Dr. Thaler believed that Davis was the inventor, and in his view, that was sufficient. But he's lost at the course of appeal. Still, Dr. Thaler gets marked for persistency, and off to the Supreme Court he goes. What's the Supreme Court arguing about? Well, it's predominantly sections 7 and 13 of the Patent Act. Section 7 is about who's got the right to be granted the patent. Section 13, the right to be identified as the inventor. I won't go into these in any great detail because they're not really relevant to what we're here to talk about, but we could do that another time if you're interested. So what happens at the Supreme Court? Well, Dr. Thaler's team bring 3 arguments. The first is who's the inventor? Dr. Thaler again says Davis, the artificial intelligence program, is entitled to be granted the patents itself because, he goes on to make the point that generally owners of AI machines should be entitled to protect the machine's inventions on its behalf. The applicant for a patent is not required to be a natural person, says Thaler. Davis created the patented ideas under its own steam with minimum instruction from human actors. The second argument, if the first one failed, was could Thaler receive ownership of the invention by Davis? Dr. Thaler believed that if Davis could not be granted the patents, he as the owner should be able to apply and receive the grants. And argument 3 was about procedural errors by the Patent Office at the point of application. I'll be honest with you, they're really boring. I'm not going to talk about them because they're not relevant to this session at all. We're here to debate the idea of IPR ownership and not the procedural issues with the Patent Office, which for the most part were dismissed by the Supreme Court anyway. If you're interested, we can talk about those another day too. So, what does the Supreme Court say? Well, argument 1, Davis should be entitled to be the owner of its intellectual property. Response 1. This is quoting Lord Kitchen at paragraph 55 of the Supreme Court. He says, I should say straight away that this issue has been decided against Dr. Thaler at every level in these proceedings by every judge who has considered it. If ever an opening sentence said, you're about to lose and lose big time, surely it was that sentence. He then goes on to say, the view of the Patent Office is entirely correct. The Act permits only one interpretation. An inventor must be a natural person. And Davis is not a person at all, let alone a natural person. It is a machine. Argument 2. If Davis cannot be registered as the inventor, Thaler should be registered instead because he owns Davis. Response. Quoting Lord Kitchen, he says, Dr. Thaler faces 2 formidable difficulties. The first is that Davis has no legal personality and cannot be an inventor within the meaning of the Act. The second is that if not an inventor, the applicant must be a person within Section 72B, and Thaler does not satisfy any part of that structure. In other words, he cannot take title from a thing that can't give it to you. All of this leads us to 2 conclusions. The first is that if a new invention is created by AI, and the AI program cannot become the registered proprietor of the invention. The second is that the person who owns the AI program cannot take title from the program in the same way that an employer can take title of a patent from an employee. Some final points of intrigue in this otherwise brilliant case. The first is about politics. Lord Justice Lang in the in the Court of Appeal says whether or not thinking machines were capable of devising inventions in 1977, it's clear to me that Parliament did not have them in mind when enacting the law. If patents are to be granted in respect of inventions made by machines, the 77 Act will have to be amended by Parliament. In other words, this is not a legal problem. This is a political problem. It's a social problem. Can we give rights to machines that don't have any legal personality? Which leads on to the second point of intrigue. The decision actually may have reached a different outcome if Davis had been granted legal personality equivalent to that of a company. Throughout the Supreme Court decision, the comparison is made and distinguished between a company, which is, let's face it, an entirely fictitious legal concept that we have created to make economies work, won't be granted to machines in the same way. But if it were granted, then the court said, well, we might reach a different outcome. But because machines, autonomous or not, don't have legal personality, we can't find. Success hiding in the jaws of defeat. Quoting Lord Kitchener, para 52, he says, it's important to reiterate that in this jurisdiction, it is not and has never been Thaler's case that he was the inventor and used Davis as a highly sophisticated tool. Had he done so, the outcome of these proceedings might well have been different. That's gotta suck. Some final other points. Dr. Thaler, not so innocent. Dr. Thaler's case was actually a test case forming part of a much larger project. For more information on that project, you should check out artificialinventor.com. Quoting from that website, it's a pro bono test case seeking intellectual property rights for AI-generated output in the absence of a traditional human inventor, or it's intended to promote dialogue about social, economic, and legal impacts of frontier technology. And finally, did he win anywhere else? No, he didn't. The European Patent Authority also rejected Davis' application for pretty much the same reasons as the Supreme Court. I'm going to end the screen share there. This is the part where I really hope I click end share and not end session. Lots of people freaking out behind you. And I welcome you back into the room, and I'm going to introduce you to Bill Bilney, who is Cripps' resident intellectual property expert. Bill, welcome to the webinar.
Hi, Matt.
If you could be any kind of dog, what would you be?
Oh, put me on the spot there. I think I'd be a Great Dane.
What's your favourite kind of milkshake?
Torn between chocolate and strawberry. I'll go strawberry.
Best day of the week is?
I'm gonna have to go for Friday.
Excellent news. Having passed that test, let me ask you some questions about the case. So, you're an IP specialist. As soon as you heard about this case, did you think, it feels really obvious to me how this is going to end? I think I know where this is going, or were you surprised by the outcome? Did you think it would go a different way?
I think, well, first of all, I think this is a really interesting case, and who doesn't love a test case that seeks to test the law? And I think with this case, unfortunately, when it got to the Supreme Court stage, I think the writing was on the wall, particularly bearing in mind Dr. Thaler had lost all the other previous stages. And when we distill the case down to its nuts and bolts, effectively it boils down to interpretation of a distinct set of provisions within the Act. And as we know, with interpretation, there's only so many ways you can construe wording. And I think with that in mind, I think that the judge's hands were tied to some extent. And what I did find fascinating, though, was that the judges were looking at the Act and sort of with part of the interpretation thinking, well, what did they have in their minds when writing that Act? And clearly back then, they thought it likely that, or unlikely, that the people writing it would consider machines creating inventions.
Seems pretty far-fetched, doesn't it?
Exactly. And then fast forward to today, and now that definitely isn't far-fetched. And so I think this case is very much an example of technology evolving to such an extent that now it's really testing the law, and the law now needs to react and evolve as well.
So, what would you do if a client walks into your room, into your office, into wherever you're doing the job, and says, Phil, we've invented something. We kind of did it with a bit of AI and a bit of us. We're not really quite sure who the inventor is, but we want to protect it. What would you say to them?
I would say that's awesome news, first of all. And then, sort of assuming the invention that's been created is patentable, I think that the next key question, particularly in light of this case, is, well, what role did that AI play in creating that invention? Was it solely and autonomously down to the AI, or was there some human intervention and some human input? And the reason why I say that is because ideally, particularly in light of the judgment, we want to be arguing that AI was being used as the judge thinks,
sophisticated tool.
Is exactly right, highly sophisticated tool. And so in that scenario, as the judges alluded to, there is still some hope there to be able to get a patent. So I think, it really comes down to, well, what role did the AI play in the creation process?
Last question. Do you think that a new law is required? And I suppose What do I mean? Well, is a new law required? But if it is, what kind of law is that? Like, how do you go about dealing with this?
Good question. I think my personal thoughts are I think the law does need to change. Whether it's a new law or an update remains to be seen. But I think that there does need to be some changes, because I feel like we can't have this scenario whereby we have machines such as AI creating inventions autonomously, but then no means to protect that invention, particularly in respect of patents. Because ideally we want to be able to incentivize people to use AI and create weird and wonderful inventions, but give them the chance to have to be able to protect them. So I do think a change is needed. In terms of what form that takes, I think that's really going to come down to Parliament and the legislature, but hopefully we'll get an input into what that should really say and look like, to make sure that what those changes are appropriate.
We've got time for a few questions, and one of those questions is brilliantly is, what does DAVA stand for? I can't remember. I was racking my brain trying to think about it. I actually wrote it down. It stands for, amazing assistant, thank you, Device for the Autonomous Bootstrapping of Unified Sentience. What a fantastic name. Thank you very much, Jazz, for rushing to the rescue there. How did Dr. Thaler get on in the rest of the world? Broadly unsuccessful. I think if you look at the website, the Artificial Inventor website, there is mention of some success in the US, but really the whole thing about Artificial Inventor is it's trying to deliberately push boundaries in a place where those boundaries exist, and I think it's actually a brilliant thing. Definitely go and check it out. Does the final point you raised from the judgment about the outcome perhaps being different if you'd argue that the inventor used sophisticated tools? Bill, I think you've kind of picked that up, which is, yeah, if the inventor comes in and says, I've invented something using this tool, that's different to someone coming in and saying, I own some IP, I own an AI machine, and that machine has invented something. They're cases of distinction, I think.
Yeah,
right?
no, they're correct, exactly. I think that the bottom line is, ideally, when you're looking at the inventor, you want to be saying that it's a natural person rather than AI.
And one last question before we move on. Even if the AI program had done the majority of the creation of the product, would it still be possible to just register the human as the inventor? I feel like it's kind of the same question, but this is going to be such a brilliant area to look at, because the rate of invention by AI is not going anywhere. It's only going to exponentially grow over the next, 10 years, 20 years? And I suppose the question that the last person was asking is, well, where is the dividing line between the inventor, the invention, and the AI machine? How much AI input, how much of the person? I mean, that's going to change on a case-by-case basis, I'm sure.
Exactly right. And remember, when we talk about who the inventor is, we're talking about who the actual deviser was. And deviser in this sense, according to the Act and how the judges saw it, was that deviser needs to be a natural person, not necessarily AI. So yeah, this judgment unfortunately does put the cat amongst the pigeons in terms of being able to try and get a patent for
the cat amongst
AI,
the pigeons.
Yeah, autonomously creating inventions.
We love cats amongst pigeons on this webinar, Bill. That's brilliant. Thank you very much. We will do more on IP and AI and the Thaler case if you want to hear about it. When you get the chance to fill in the feedback form, if you'd like it, please tell us and we'll make sure to keep talking about it. Right. We're going to go on to the third section, which is all about the UK's AI Act, as in the act doesn't exist. Bear with me as I attempt to try and share my screen. Everyone's holding their breath again. This is good fun. Ta-da! Hopefully you can all see a picture of yummy lunch. Right, the third session, all about the future of AI law in the UK. So, for those of you who weren't aware of this. In 2023, the government started a consultation on what the law in the United Kingdom should be about regarding AI. I was really privileged to be involved in that with a fantastic team of people. We spent a long time producing a very detailed response to the government. It was great to be involved with. And I think it was the 6th of February this year, so less than a month ago, the government published its response. It was like they knew we were launching a new webinar series and they wanted to give us a little present to say thank you. I've spent the last month reading that. It's over 108 pages long when you print it out. It's really detailed. There's a ton of annexes as well. I have to say, the outcomes broadly are what I thought they would be. It's an absolute wash with government rhetoric. So if you find that stuff a bit galling or tiresome, probably don't go and read the whole thing. What we've tried to do here is distill it down into the most important points, which are the principles, the risks, and then some of the responses. We've only got time to look at these in high level, but we'll do the best we can with the time we've got. The first thing you should know about that consultation is the 5 AI principles. These were in the consultation initially, and they've stayed in the response. The government thinks that when it comes to the AI and the law, the most important thing is safety, security, and robustness. The second principle is appropriate transparency and explainability. We pause there for a second. We could probably do an entire webinar on just that principle. The explainability point is actually already in the GDPR for anyone who's looked at the Article 22, Regulation 22 GDPR and the accompanying recitals talks about the ability to explain AI to people. What they mean by that is you have to be able to explain to the person whose data is being processed what the AI machine is doing with their data to reach a particular outcome. It's an immense topic. How do you explain something which is fundamentally very hard to explain to someone who fundamentally may not care about listening to you? What a fantastic topic. We should definitely do more on that at some point. The third principle is fairness. The fourth principle is accountability and governance. And the fifth is contestability and redress. So the ability for individuals to challenge decisions made by AI and to seek redress if they are wrong. They are the main principles, or sorry, the only principles actually, the 5 principles. What else from the response? Well, the government highlighted three risks. The first is societal harms. The second is AI misuse. The third is autonomy. And they get even more brilliant and fantastic as we work through them. But we'll start on risk 1. Basically, risks to employment law, intellectual property rights, we've just talked through, bias and discrimination, data privacy and information rights, competition law. All of these are the societal risks that the government has identified as being posed to all of us by AI. Just picking out a few of these, regarding intellectual property rights, we've just talked through the Thaler case in detail. You know, that's a very recent case. It's very cutting edge. You know, there's still a lot of reaction to that case happening right now. But one of the things that it sort of resulted in, I suppose, or was maybe connected to in a way, is the fact that the Intellectual Property Office announced at the end of January that its own attempt to try and reconcile how AI and intellectual property rights mesh together had failed, and they weren't able to reach any conclusions. All the government has to say about it in the consultation is, we will soon set out some proposals on the way forward. Expect another consultation. Another one which is fascinating is obviously data privacy and information rights, one which is very close to my heart. The government says at section 513, current rules on automated decision-making are confusing and complex, undermining confidence to develop and use innovative technologies. Pausing for a second, I'm not entirely sure that's true, but that does seem to be what they think. They go on to say the DPDI bill will expand the lawful bases on which solely automated decisions have significant effects on individuals. So you kind of get the flavor from risk 1. Bias and discrimination is also an area that's really very, very interesting in the world of AI. So interesting, I think we should definitely do a whole session on that at some point. So then the societal harms, the misuse risk. Misuse in this context means really, really big misuse. Not like just getting little bits wrong here or there, but misuse as in affecting the democratic elections. The government spend a lot of time in the response talking about electoral interference, quelle surprise, and things. So they say here, for example, the aim of the Elections Act that they're bringing in is to protect voters from improper influences to vote in a particular way or not to vote at all, and include activities that deceive a person in relation to the administration of an election, such as the date of an event or location of polling station. We don't have time to get into this too much, but one thing which is really interesting is the extent to which external threat actors like, well, typically Russia, but other places too, try to influence democratic elections. This is the year of the great vote. There are 70 democracies going to the polls this year, one of which, of course, is the United Kingdom. Expect to listen to lots and lots said about how AI is influencing how we vote this year. You might get a bit bored of it by the end, but hopefully, if nothing else, we'll try and keep it fun. There's also a lot on AI crime and warfare, which I'm not going to talk about too much now, but basically AI influencing decisions about how warfare is undertaken, and some things on consumer protection as well. Autonomy risks is basically the government worried that the matrix may actually happen. What a fantastic quote this is. Some experts are concerned that if AI systems become more capable across a wider range of tasks, humans will increasingly rely on AI to make important decisions, and AI systems may have capabilities to actively reduce human control and increase their own influence. What a brilliant time that will be when AI looks back at humans and says, I don't think you guys should be involved in this as much anymore. To resolve this, the AI Safety Institute has been created. Well, here's a quote for you, if ever it were telling, taken from pages 23 to 31. One of the government's first challenges is knowledge. We do not fully understand what the most powerful systems are capable of, and we urgently need to plug that gap. That is what the AI Safety Institute has been created to do. Let's talk about the responses. So we don't have time to go into these. Each one of these bubbles expands and collapses into its own thing. We could be here for quite a while, but we've only got 7 minutes left. So I'm going to show you the ones that I think are the most important to us as a group. The first one is all about law, because that's why we're here. Consultation questions are basically, do you agree that the implementation of the principles, that's the 5 things we looked at a few slides back, fairly allocate responsibility? And the majority of the responses were no. There was repeated acknowledgement of the complexity in the AI value chain, but there was no real agreement on how liability should sit within the AI lifecycle. 25% of respondents to the consultation said that new law was needed, and some suggested the importance of a legally responsible person akin to a data protection officer for AI, which I thought was a really good idea. The government's response, at paragraph 76, they say, we will only consider introducing legislation if we are not confident that voluntary measures will be implemented effectively by all relevant parties, and if the existing legal powers are not effective. And then they go on to say, the challenges posed by AI will ultimately require legislation in every country once the understanding of the risk has matured. So basically, we're not going to make law now. We probably will make law at some point, and eventually everyone will have law, which kind of feels a little bit predictable. We could talk and maybe we'll do this in another session, talk a bit about the interplay between the different responses of different jurisdictions. One of the things we're going to send out to everyone who tuned into this session is a thing we're calling Put It on a Page. So we've summarized the entire consultation onto one A4 sheet of paper, possibly 2-sided, I think. And in it, we are summarizing some of the key things, and in all about this, so all about the AI consultation. And one of the things in there is a quick side-by-side on the absolute headlines between the EU AI Act and the UK Act that doesn't exist. Let's look a bit at statutory duty very quickly. So consultation question was, do you agree that there should be a statutory duty on regulators to have due regard to AI principles? The response was basically yes from everyone. So obviously makes a lot of sense. And the government response at paragraph 109, we anticipate introducing a statutory duty on regulators requiring them to have due regard to the principles after reviewing an initial period of non-statutory implementation. They then go on to say, we will not rush to legislate. We think the non-statutory approach offers critical adaptability. We ask regulators to publish a strategic approach to how they're going to do this by the 30th of April. The thing with that is, well, I think this is legislation light, or it certainly could be. At some point in time, the regulators will have a statutory duty, i.e. they have no choice about doing it, to follow a set of non-binding principles in a world of fast-moving tech law. What could possibly go wrong there? It's going to create a tidal wave of non-binding, sort of binding, sometimes binding guidance. I think it's going to possibly put us in a sort of quasi-legislative position. It's going to get fairly complicated fairly quickly, if nothing else. Right, I'm going to stop sharing there. So watch as everyone panics. Excellent news. And I'm going to welcome us back into the room because we want to end every session with a thing called 3 great things. Most boring law firm webinars will not ever for a second invite onto the screen the people who actually do most of the really hard work. But we are not a boring law firm, and this is not a boring webinar. So let me introduce to you from my right to left, Louis, Alice, Jazz. 3 great things that AI has done in the last 8 weeks that are just interesting, fascinating, or peculiar. Jazz, I'll go to you first. In your research, what have you found that AI has been doing that really caught your eye?
So I found that a recent development in health tech, driven by advancements in AI, has resulted in the creation of a 2-legged biohybrid robot.
Hang on a second. A 2-legged biohybrid.
So researchers in Japan have essentially created a new robot that combines lab-grown muscle tissues and artificial materials.
Cool.
So robotics in healthcare currently do specific tasks, such as assisting in surgery for delicate procedures, or in recovery where robotic exoskeletons are used for rehabilitation. But now, and as you can imagine, robots' movements are quite clanky and quite rigid, which limits its use and its application comparatively to humans, who are quite flexible, agile, they've got fine movements, and they can convert energy efficiently into movement. So drawing inspiration from the way humans walk and the muscles can sort of contract and relax, this new creation allows robots to seamlessly move, walk, and pivot.
Amazing. So this is AI creating a new field of robotics. Wow. Alice, what did you find?
Hi folks, this one's for my fellow aviation enthusiasts. From the cockpits of commercial airlines to the training grounds of aspiring aviators, artificial intelligence is like the co-pilot you never knew you needed. Who said VR was just for gaming? We're talking AI-powered flight simulators that make Top Gun look like child's play.
Cool.
Simulators can mimic incredibly realistic environments, giving trainee pilots the ride of their lives, and without the risk of crashing. Then there's the brainy stuff. Gone are the days of static instruction manuals, and forget the one-size-fits-all training. Think of it like having a personal flight coach, minus the cheesy motivational speeches.
So this is AI training pilots to fly?
Pretty much. Imagine having a virtual instructor that never sleeps, never gets cranky, and always has your back.
Amazing.
That's AI for you.
Louis, let's move on to you very quickly. In your research, what did you find?
So continuing on from what Alice said, still looking up, AI is helping us in our search for extraterrestrial life as well. So it's being used to widen the range of radio signals that we can listen to and analyze far greater amounts of data than was previously possible. That's all happening in New Mexico at the Very Large Array. Imagine loads of massive TV satellite dishes. It's really early days still, but the results need to be verified by other observations, but our chances of detecting extraterrestrial life are increasing all the time.
I literally love that. So just to round up, we've got AI in healthcare and robotics, AI helping pilots to fly better, and AI finding aliens. You heard it first. This has been the CRIPS AI and Data webinar. I hope you've really enjoyed it, and I hope you'll join us next time when we will be back on Monday, the 8th of April, not Monday, the 1st of April, because that is a bank holiday. If you tune in, we won't be here. Tune in instead on Monday, the 8th of April. We'll be discussing artificial intelligence, lawful bases, and the ICO's consultation. We'll also be unpacking the TikTok 2023 monetary penalty notice case, which was easily the biggest case the ICO did last year. It's got a ton of fascinating stuff on privacy policies, data governance, how all those things fit together, plus a really big dollop of tech contract as well. So if you're interested in that stuff, come and join us. We'll also have 3 great things for you from the Crips equivalent of the QI elves. What will AI have done in the coming 4 weeks? I don't know. They'll find out. Until then, thank you very much. Have a fantastic rest of your month. Adios.